Appeal Number 60, People versus Viruet. Counsel?
Good afternoon. May I reserve 3 minutes for rebuttal? My name is Layla Hull from Appellate Advocates representing Mr. Viruet. In this case,
Ms.
this
Hull,
court should...
would you like some rebuttal time?
Oh, I'm so sorry. I meant to reserve 3 minutes.
3 minutes?
Yes, please. This court should enforce the rule...
Counsel, what is on the tape, or you believe is on the tape, let's put it that way, that would have been of use to the defense, given that the camera was not pointed in the direction of the shooter? What's of value there?
So the tape, it seems to have been pointed in the direction of right in front of the club in this case, where both the shooting took place and the events preceding it, which was everything the people's witnesses actually testified to. The entire people's narrative took place right in front of that club, right in front of that door, where one of the witnesses, Herbert, was the bouncer, and he testified that he was placed there.
Well, what is it the defense disputes about that narrative?
Well, the main issue is that the one thing the defense could have disputed with it is the fact that whether the witnesses during the shooting were really in a position to have meaningfully observed the shooter. There's also a good question about what the vantage point of this camera was, because the defense is never going to be in a position to conclusively establish what was or was not on it. The
But
point
counsel,
is,
if you look at the record and go through where this was raised, and I think it's just about 2 short inquiries with 2 different witnesses, one bouncer and one a detective, I think, there really is no follow-up as to where were you in the area covered by that camera when these events were occurring. This defense counsel establishes there's a taping system, generally what it covers, and I think there's some discussion about taking the tape even on direct, but there's no follow-up by defense counsel as to where those scenes you describe actually took place, and there is some testimony that they may have moved to the side of the door. So was there an obligation on defense counsel to follow up to make that record?
not under this court's decision in Handy, because even in Handy, there was an acknowledgement that the only record available was that it showed a very small part of one of 2 assaults, and critically, the assault that actually the defendant was acquitted of. And yet, because it showed part of the chain of events, and even that cross-examination in this case, or as part of the direct, we do have a record that shows that Herbert says it does show the witnesses to the shooting at the time of the shooting. So that's a very small part of the overall sequence of events. So even there, you've got that. And critically, the police officer clearly recognized that this was material, because after looking at it, he collected it. The police's actions here are proof that this was material evidence.
In the Handy case, that the evidence was destroyed. You want us to extend, basically, Handy's analysis. Is that right?
No, I don't think so. Maybe this is my reading of Handy. I read Handy, and I understand telling you what my interpretation when.
No, it's fine. You go ahead.
It's dangerous ground, I'm aware. Handy seemed to me to be an opportunity. The court could have exclusively limited its ruling to kind of intentional destruction, and it didn't. And one of the reasons, I assume one of the reasons for that is because the way this court has always looked at lost or destroyed evidence.
Well, the spoliation rule is lost, altered, or destroyed in a civil context. It seems that you're asking for something similar to that.
Well, the people always have an obligation in the criminal context to preserve evidence. And that's what I think we're looking at here, and the failure to preserve evidence. So it sort of doesn't matter if it's lost or destroyed. That's a distinction without a difference, or difference without a distinction. I always screw that up.
Would be reflected in the charge as well, right?
Yeah.
That you would ask for, whether it was, I think in Andy, it would be deliberately destroyed after being requested or lost, essentially.
Absolutely, and actually that is something they could clarify. But we also cared about giving the defense an opportunity to look at evidence that is reasonably likely to be material.
So it's sort of policy-based that whether it's lost or destroyed, you want to encourage good practices of preserving the material?
Yes, and this case is a very good illustration of why you want to care about it, even if there isn't an affirmative record that it was intentionally lost, because you have a detective here who didn't follow proper procedure. He was careless. He didn't have the DVD, he didn't have the tape put on DVD, which was proper procedure. He didn't voucher it, which was proper procedure. And when it was lost, he didn't write a report. I mean, all of these things sort of point to a level of mishandling that we should be very, very concerned about.
Are you at all worried that the rule you're asking for is one that would encourage the police to, in this case, or cases like it, look at the videotape, conclude, this is really not good for the prosecution, and then not take it at all?
No, because there's already a rule that the police don't have to gather exculpatory evidence. I mean, that's one that we oftentimes have this argument in the appellate division, which is whether the police should or should not have taken the evidence. But clearly, this officer did recognize that it was material.
Well, if you know, what's the police protocol for copying that video?
My
They
understanding,
do it automatically?
my understanding from the record in this case is that he was supposed to contact the TARU unit, T-A-R-U, and have them transfer the footage from the VHS onto a DVD. And presumably the reason for that is to make sure this doesn't happen, that it isn't left unsecured.
But I'm sorry, so my question was, does that happen automatically, or is there, as Judge Wilson is suggesting, the potential for an assessment up front so that you never copy it and never get it to the precinct?
I don't know for sure. I would make if I can make an assumption, I would assume that anything that comes into the NYPD in that form, because of the format it's in, you want to preserve it. And
Ms.
so,
Hull, is there a reasonable view of the evidence for the jurors that this was just sloppy police work?
yes, I do think so. But I don't think that is a substitute for giving the charge.
No, absolutely.
But there is a reasonable view of the record that this was sloppy police work, and I think that's one reason why we have a concern about making sure that both the deterrence is still valid here, but also I don't want to lose sight of the fact that the defense has lost an opportunity to view objective evidence of what actually happened. The people were able to...
If we accept your proposition that Handy applies in these circumstances, does harmless error analysis apply?
Yes, and the jury here was stuck for deliberating for over the course of 2 days. They asked for readbacks of Jesse Garcia's testimony as well as, and I see my light on, so I'll go quickly, as well as Herbert's testimony. They asked for all of the exhibits. This was not an open and shut case for the jury, and with good reason, given the fact that the identifications in this case had problems. And I'm happy to address Jesse Garcia's testimony on rebuttal if you want me to.
Fine, thank you.
Thank you.
Ms. Talcott?
Good afternoon. May it please the court. My name is Nancy Fitzpatrick Talcott from
Miss-
the Office of Richard A. Brown, the District Attorney of Queens County, on behalf of the respondent.
Ms. Talcott, if the tape had not been lost, what are the people's discovery obligations vis-à-vis that tape?
As the prosecutor pointed out in response to the missing evidence charge request, it was not discoverable. The prosecutor did not intend to submit the trial in evidence, therefore it wasn't discoverable under 24020, nor would the duty to preserve apply as a matter of fairness, as in the case where the people, the government it was in the exclusive control of the people, because this in fact was made by a third party to which the defendant had equal access. There was no claim whatsoever that the defendant made any attempt to procure it. A simple call to Scoobies after he was arraigned on the complaint would have
It's not
sufficed.
potential impeachment material?
No, because it's not a dispute that the video camera was irrelevant to who was across the street shooting. I don't think the defense contends that. So then the question becomes, their speculation is we might have been able to impeach them on the earlier incidents. However, defendant failed to even establish that those earlier incidents were on the lost video. He basically asked for a charge about evidence that he didn't establish even existed.
But how can he do that when he doesn't have an opportunity to see the video? And why isn't it an appropriate inference that if you have a security video outside the club, it is playing the entire time the club is open?
Simply asking
If it's going to be on later, I mean, you don't dispute that the point in time when the shooting occurs, that tape is running.
Oh, no, absolutely, and that's the tape that Detective Ragab saw, and that's what he testified to. Now, that it showed people coming in and out of the door all evening, well, of course, it
But
was
counsel,
established, that was the
That
vantage
tape,
point.
at a minimum, as I read the transcript, shows the actual murder, right?
Exactly.
So it's a difficult argument, I think, to say it's not material if it's actually showing a killing. And I understand your point that the shooter's across the street and is clearly not on this tape at that time. But I think to Judge Rivera's point, as you read the testimony, there is certainly a strong suggestion that all those witnesses are at some point in the range of that camera. And given that this is basically a two-witness identification case, plus I know you had a cooperator, but how can that not be material? When you're seeing the people on that video at some point in these altercations or not, on that video, and seeing what they were wearing and seeing other things that were subject of that testimony, it seems a difficult argument to make that that would not have been material for the defense.
Well, one, it's not clear that, again, simple questions, asking whether they were within the range of the, you can't expect that 20 people were in front of the door. They said there was a big crowd at the second incident where the defendant actually came. There's no indication defendant
wouldn't
was
the-
ever in view of the camera.
Excuse-
Stephen, probably, because he came out a couple of times.
Excuse me. Wouldn't doesn't the tape establish impeachment material that you would use to go to the circumstances of the crime itself? Even though it doesn't show the shooter, it would seem it's got to be reasonably related to any impeachment questions that you'd want to bring to the circumstances of the crime. On top of that, you have someone testifying to saying what was on the tape, and then the tape isn't available.
Well, what you had two people testify as to what was on the tape was people running in the bar as
I don't
the-
dispute with you at all the
Right.
circumstances
So
of what it
we
shows.
don't even know whether the earlier incidents were captured on the tape. So again, he's asking for a charge based on evidence, because the impeachment claim is that it would go to the prior incidents. He didn't even establish the basic questions whether those incidents were captured on the tape.
But isn't that the point? How is the defendant going to do that without having an opportunity to see the tape? And all they want, isn't this the minimal request? Just an adverse inference charge. It's like the de minimis in many ways of what they're seeking or sought.
We're not saying he has to establish what was on there, but what he had to establish. Detective Ragab, when you viewed the earlier incident, did you view the tape from an hour before the shooting? Say he said yes. Was there any indication of any verbal or physical altercation before? Yes. Okay. Now you've laid your foundation. Now, obviously, he can't get into specifics about what that would show then, but he didn't even establish that the altercations were on the tapes to begin with. That's what he would have to do at a minimum.
Counselor, as I understood your argument, you were also arguing that that the charge in question was overly punitive. And my question to you is, if the court felt that some sanction was appropriate to deter the failure to follow protocol and the apparent carelessness in preserving this potential evidence, what would be an appropriate sanction short of this very permissive and not, adverse inference charge?
Well, I think a remedy was imposed here, given the meager, if not non-existent, showing of materiality, coupled with the inadvertence, sloppy. The prosecution admitted that throughout summation. The remedy here was to give him wide latitude in cross-examining and pretty much unfettered reign on summation.
So what would your test be for in this circumstance when the defendant would get the adverse inference charge?
I think it has to be assessed, as this court has indicated, on a case-by-case basis, examining a number of factors. The evidence admitted at trial. Here we have, which goes to harmless error, overwhelming evidence of guilt, but we also have evidence, as the appellate division recognized, negating that this video would have shown anything material. Also depending on the significance of it.
But aren't you always going to have that?
Well, this
Or
court set forth the factors.
frequently, I should
that-
say frequently.
You may.
And isn't that a little problematic, and not to suggest any impropriety on the part of any of the actors here, but, wouldn't the detective sort of have an incentive to say there was nothing exculpatory on the
No.
tape?
Unlike in Handy, no, he has no cause to build a case against the defendant rather than Stephen, which is
No,
what the defense is implying.
not to excuse his negligence?
I'm not saying excuse it, but the deliberateness should be a factor, and this court has indicated the court can consider it, because the punishment is going to vary depending on the deliberateness of the act.
So let's get to that remedy. Let me go back to what you suggested, allow cross-examination and latitude on cross and broad summation, but that is still coming from defense counsel.
Right.
You agree that that's different from an instruction from the judge, right? The neutral person in the trial who is not advocating for either side, that has a different impact on the jury than if it's coming from, excuse me, counsel who's advocating on behalf of the client.
Yes, absolutely. And the
So,
court has
so then how
recognized
can
that.
your remedy be enough?
Because what the court would have said would have just been kind of a neutral, permissive charge.
And that's
He
the
let the
point,
de-
right?
right.
That it's a
And he-
neutral charge.
And he let the defendant go far beyond that. He could have limited the defendant in just giving what the court would have given. He didn't. In addition to, the defendant went far beyond anything the court would have said. And in addition to
But the
tell-
point is the source.
Right.
I think you're not responding to my question. The point is the source. One source is an advocate.
Yes.
The juror may view as, of course, working zealously on behalf of the defendant.
Right.
And the other source is the neutral person in the room who's giving that kind of an instruction. When the judge has already said, whatever the lawyers say is not evidence.
But here, he went further and invited them to adopt the arguments put forth by counsel, which included a much broader instruction than the court would have given. I agree. It's different when it comes from the court. But here, giving the meager showing of materiality, if not non-existent showing, coupled with the fact that it was entirely inadvertent.
To adopt
stop-
defense counsel's argument or arguments of either counsel? Take it for what it's worth, adopt either side.
Either, right.
Aren't we left again to the jury is going to decide who's the better advocate, who they're persuaded by, as opposed to the neutral person in the room giving them an instruction?
Well, I think they're going to base it on the evidence presented. And what they did during deliberation, that's speculative. We don't know why they asked for readbacks. We don't know why it took 2 days. You could argue that's a pretty quick verdict under the circumstances. That's just speculative, and we can't delve into the deliberative process.
Counsel, do you care to address harmless error?
Absolutely. Even if there were error, and obviously we would claim that there's not, in exercising its discretion, the proof of guilt was truly overwhelming. The defendant confessed. Jesse Garcia did have a history and cut a deal in his confession, but he was a longtime friend of the defendant. His demeanor on the stand, that made it more credible that the defendant would confess and confide to him, and actually discussed with him a plan to help him flee. The defendant, and Jesse's demeanor added to his credibility. As the prosecutor noted, he was sobbing on the stand. This hurt him, and he admitted, I did it for myself, I did it for selfish reasons, but he was testified as to the confession the defendant made. The defendant implicated himself at the scene when he threatened, I'm going to be back. Now, Xavier White commented on that 4 times. At one point, he said, the defendant said, they will be back. Either way, and defense counsel himself characterized it, where defendant said, I will be back. Defendant was coming back, be it by himself or with others. So he implicated himself even before. You have the 2 witness identifications. Xavier White, they had ample opportunity to view him at the earlier incident under good lighting conditions. They testified as to their vantage points. And Xavier White knew Stephen, because, the claim is possibly it was Stephen. Their testimony was corroborated by the ballistics evidence. Robert Garcia, also his longtime friend, as to the events leading up. Everything was very consistent. Were there minor inconsistencies? Of course. Different vantage points, fast-moving series
Was
of
there any
events.
corroboration for the cooperator's testimony in terms of where they were when these things happened? I think they were in a mall, or there were certain calls perhaps made. Was anything put in to corroborate at least time and place in terms of the cooperator's statement?
Oh, regarding like meeting him at the barber shop and then,
Yeah.
I don't think so. I don't know that they sought to dispute that as opposed to just the confession. And the jury obviously credited his testimony.
Thank you, counsel.
Thank you.
Ms. Hall?
If I could just quickly address a few points in response, and then I can turn to harmless error, unless you want me to do it the other way around. I think the fact that the people's position that this was not discoverable, counsel specifically requested it, and it was materially likely to be relevant. This was discoverable evidence. The people's argument that this was not in their exclusive possession is entirely unpreserved for this court. They never made that argument, and so counsel never even was able to respond to that claim, nor is that claim really supported by the record in this case, because even when the police officer tried to go back and get the tape, he couldn't get it. I'm not sure how defense counsel could have done that. In terms of defense counsel never being able to establish on the video the earlier incident, when you look at the Handy decision, it says quite clearly that you cannot unquestionably accept the testimony of somebody recounting what's in a kind of objective video evidence. Even if he had cross-examined Detective Ragab and Ragab had testified one way or another, under Handy, Ragab's testimony isn't dispositive as to materiality. In terms of the deliberateness, and then I'll turn to harmless error, whether or not this was deliberate destruction or carelessness, usually that bears on the severity of the sanction. As this court has already stated, this is the most measured sanction available. Also, in terms of summation and cross-examination being a substitute, I think the fact that there is a court-imposed sanction is quite significant. The juries are told that argument is not evidence, and a statement coming from an instruction from the court about how to evaluate the evidence, particularly the absence of evidence, is quite critical. Harmless error.
Before you get done, I'm sorry, counsel, what about the people's argument that this is a third-party tape? Putting aside, you could have gotten it, we could have gotten it. It's a third-party tape. Handy was essentially government, I think, a prison video.
I don't think that that's relevant here actually at all. I mean, if Handy can't, I hope, cannot simply apply to video evidence that is recorded within the four walls of a police precinct or a prison, Handy should, in my view, apply to evidence pertaining to a crime that the police have an obligation to preserve. And that seems to be the overriding policy of it, and it comes, and it cites a line of cases about collection of evidence from crime scenes.
Right. And this isn't a collection case. The duty to collect, it's a duty to preserve.
It's a duty to preserve, yes, but it's a duty to preserve evidence that has been taken from a crime scene, not that happens to be in, not that happens to be in the courtroom, for example, where we have video cameras, though preserving this video would be fine with me to go.
Harmless error?
Jesse Garcia's cooperation agreement is quite critical to this. The people point to the fact that he testified, reluctantly. He also asked to speak to the police at a particular point, and he obtained a very, very favorable cooperation agreement.
All of that was in front of the jury.
Absolutely, but what wasn't in front of the jury is the fact that objective evidence that had the potential of contradicting the people's narrative is not before you, and you can infer that would have benefited the defense. There was also aspects of his description of this alleged confession that didn't comport with the people's narrative, and that's quite critical. I mean, he's saying that someone else actually shot. I mean, my client's claiming that somebody else allegedly shot at him while he's standing on the median of the street.
None of those differences were brought up in conclusion too.
Right, but that may explain why the jury. And I'm sorry, my light's on. That might explain why the jury asked to rehear his testimony. I understand that we don't want to sit there and decide what the jury was thinking, but it is significant that they wanted to hear his testimony again. And a large part of his testimony was extensive cross-examination about whether he was credible. And
Thank you, Ms. Hull.
Thank you.
Thank you.